I'm Ken Carlson. I've been a renter's rights attorney since 1980. This is the next in a series of free video consultations brought to you by my website, caltenantlaw.com. Today we're talking about the landlord selling the place where you live. Here's the familiar scene. Your landlord says he's going to sell the house or condo that you live in, and that the real estate agents are going to be showing the property. He probably knew he was going to be doing that months ago, or before he even rented to you. But in order to keep you paying top dollar rent until the last minute, he's just springing it on you now. You may already have had real estate agents coming in to take pictures of your place and furnishings to post online on the multiple listing service for potential buyers to see, and bossing you around. They may already have posted a lockbox containing a key to your front door and a for sale sign out in front. The landlord may say that you'll have to be out of the house during open house weekends, and that you'll have to cooperate with his real estate agents. Sometimes the landlord plans to come in while you're living there and do major repairs and upgrades that he refused to do for you, so that the place shows better and sells for a higher price. He may suggest that you will have to move out in the middle of your lease in order to make the sale happen on time. Did you notice anything missing from this set of plans? Good guess. Respect for you. He sells the house, but sells you out. He's expecting you to just surrender your exclusive right to possession, your privacy, and your lease, to let strangers walk into your house, disrupting your home with construction, all heading toward the inevitable eviction in thanks for your cooperation in helping the landlord make a huge profit. Out of all the situations that tenants can find themselves in, this is one of the easiest for you to control and to convert to the best results for you. You just need to take control. Let me show you how. Since you're going to be evicted eventually anyway, you really have nothing to lose by sticking up for yourself here. It's only a question of how and when. If you do cooperate in every way, the landlord still evicts you with not so much as a thank you. If he's planning on invading your home with contractors, real estate agents, and looky-loo buyers, you're already losing your main reasons for renting the place. If he's planning to push you out during your lease without enough time to find a new place or make the money to make that move, you're already in a desperate situation. Taking control changes all that. And you might as well, because if he gets his way, you've got nothing to lose. When you rent the place, you buy, on a temporary basis, the exclusive right to possession. That's what renting is. Even the landlord cannot just come in. He is trespassing. Sure, he owns the property, and eventually will have the right to possession after you leave, but you own the right to possession by being a tenant. That changes everything, because you legally have the right to determine who can come in, why, when, and under what circumstances. If the police are called, they will side with you, and if they don't, their watch commander or police captain will spank them. So, all these plans that the landlord had about what he's going to do have one important condition: only if you let it happen. You are the only one in control. That means that you can make the real estate agents remove the lockbox, remove the for sale sign, and remove any pictures of your home from the multiple listing service website. You don't want just anyone with access to the lockbox to think they can come into your home anytime they want. You don't want a for sale sign out front to attract passers-by to knock on your door and ask to see your home. You certainly don't want pictures of the interior of your home on a public website where burglars can case your home to see what they could steal. You don't want pictures of your home made public at all, because it's a violation of your right to privacy. If the real estate agents give you any resistance, you simply remove the sign yourself, remove the lockbox, and sue the real estate broker for trespass and invasion of privacy. They have no defense that the landlord said they could do it, because It wasn't the landlord's rights being given away. It was yours. And you are not surrendering them. You can charge the broker rent for storing his for sale sign and for its positioning in your yard as well while it was there. By the way, I was a real estate salesman before I was a lawyer, and I taught the Department of Real Estate course on landlord-tenant law to real estate brokers. I know what they should know, and that they think they can get away with pushing around tenants so that they can make their commission. You get arrogance and rudeness from them until you take action against them and cut them down to size. As the only exception to the landlord trespassing, Civil Code 1954 permits the landlord or his agents to come in, but under very limited circumstances. They can come in to make repairs, which can include checking the thing that needs repairs to assess the cost and identify the parts and tools needed. They can come in to show the property to prospective buyers. They have to give 24 hours notice to come in and can only come in during normal business hours. That includes weekends for real estate agents, but for no one else. Most importantly, they cannot abuse the right to enter. Making repairs does not include making improvements, like putting in a new kitchen counter or new carpeting. As long as repairmen are there, you can give the landlord a list of things that you've wanted to have him fix all this time and take pictures of the repairman fixing it to show that the landlord did not previously fix these things during your tenancy as just one of his breaches of contract. The landlord may want to make major repairs, like removing mold from the walls, replacing kitchen cabinets, and other projects that turn your home into a construction zone. That is such an abuse, and you can legally refuse to let him do that. If the workmen come in to make a minor repair but then start doing more, you can tell them to go. And if they don't, you call the police to arrest them, or make a citizen's arrest using all force reasonably necessary to subdue the resisting criminal suspect, and then sue them and their company. You probably won't need to do that, but knowing you could is awesome. Before you allow a repairman, you have the right to ask what exactly they are doing and how long it will take. They should have a business card so you can call their company. If they don't know how long it'll take, they can estimate. You can say that today is not a good day for this because you have to leave in a couple of hours and you're not going to leave them alone in your house. You can call their boss to see what it is that would be done and how long that would take. And if you get the runaround from them, say you're not permitting it. You can guard them like a hawk, taking pictures of them and of them working. And if they don't like it, they can leave. This is your home and a disruption of your privacy and exclusive use and activities. Showing the property to potential buyers does not include a caravan of agents from the landlord's listing office. That is, when a broker is hired to sell the landlord's house, the agents of that office all travel from one new listing to the next to get familiar with this new inventory to sell. You don't want things broken or stolen, your floors made dirty by the shoes of the salesman, or your privacy disrupted by their coming in. They're not buyers, so you can legally prevent the caravan from coming in. Using your home for an open house, especially where they expect you to stay away for the day, is a ridiculous abuse of the right of entry. An open house is functionally a satellite real estate office that brokers use to pretend to give more attention to a particular sale, but in reality, it's only used when the seller is asking too much for the place. The real estate salesman camped out at your home shows the people who come by not just your place, but the identical house down the street selling for less. Yet another abuse is when there are just too many showings. The abuse mentioned in Civil Code 1954 is not defined, so if you think it is an abuse, it is. A judge may disagree, but it would never get to that. It's also an abuse to have the buyer look in your closets or take more than a few minutes total time to inspect your house. Hanging out for a half hour is abusive. You can pull the plug at any time. Get out. You're in control. The real estate agent who brings in someone must give you their business card to identify who they are. A professional agent would call to say, "Hello, I'm Barbara Dahl, the real estate agent. I'd like to show your place to one of my buyers tomorrow at 10 a.m. or whatever's 24 hours later. Would that be okay with you? Will only be a few minutes. If not at that time, is there a better time? Thank you very much." The advance notice before coming in must be written on paper and received by you at least 24 hours in advance. The only exception to that is where the landlord gives you a letter saying that for the next 120 days the property will be shown by real estate agents who, in that case, may just call you 24 hours in advance. The notice must identify one of these limited reasons for entry and give the date and time of the entry. It has to be during normal business hours, essentially 9 to 5. A notice that gives too broad a time range, like between 9 and 2, is too broad and disqualifies the notice. If you don't get enough notice or other circumstances make it unreasonable, like you're having a party or someone in your home is sick, you can legally prevent them from coming in. You can legally refuse entry. "How dare you interfere with my plans?" your landlord might arrogantly say. You can respond that you're exercising your rights under the law and that his threats are retaliatory. You can video his talking to you like this. You politely say that he needs to be more respectful of your rights and offer reasonable compensation to you and reasonable conditions for your cooperating with his plans. It's best if you put that in a letter that you can make a copy of to show a judge in case it gets to that. Limit showings to 5 per week. No open house. You make the place look good for the buyers to see. Realtors call it staging. And you stay out of the way during showings. In exchange, he reduces the rent by 50% during the months of the showings and gives you at least 60 days' notice to move with your full security deposit and a bonus of $10,000 or more paid out of escrow and included in the escrow instructions. You want compensation for things being broken during your tenancy that the landlord did not fix as a percentage of the rent you paid. He takes full responsibility for anything damaged or stolen, and no repairs will last longer than 3 hours without extra compensation. No remodeling will be done without extra compensation as well. All construction work will end with a complete cleaning of the dirt and debris, and the place restored to its original condition before the work began, with furniture and so forth put back where it was. The pictures of the interior will not be shown on the internet, on websites, and all buyers must be escorted by the agent and not be allowed to split up and look in different rooms at the same time, which could permit theft and damage. A buyer is anyone who says they are, even burglars. You want a glowing letter of recommendation that you can show to your new landlord. You might want to put these requests in a letter entitled Win-Win. The landlord will probably think that this is ridiculous and refuse to do anything like that. He may threaten to evict you, which is yet another retaliatory act, but then he's in even deeper. You tell him to remember that you made this offer and he said no, because you will not hear him whine in the future that you were unfair to him if things don't turn out as he thought. Don't tell him what you'll do if he asks. Tell him he'll find out the hard way, and leave it at that. Here is what you can legally do, just so you know the tools in your tool belt, to be used as needed. I'm not telling you to do these things, but only giving you ideas that you can decide upon if needed. If the landlord doesn't respect you, he can fear you. You don't get physical, you get fiscal. Hurt him in the wallet, where everything he treasures resides. They bleed greed. You can effectively slow or stop the sale of a property, not to cause him harm, but as collateral damage from your legal assertion of rights. Of course, that would cause the landlord to lose the market value of the property while still having to pay insurance, taxes, and other expenses of ownership, as well as his hopes of cashing in. It's a downward spiral for the landlord, while all you would owe is perhaps some reasonable value for occupying the house under siege, but not rent. You can cause the landlord to respond to citations by the inspectors from the building department, fire department, and health department that you call. If the hostility escalates, you can let the potential buyers in, but you're not required to remain silent during a showing. You can require them to show identification so you have a record of who came in case something is stolen or broken. You can tell the prospective buyers that you're going to sue your landlord, and if they buy the property, they will have to be named in that lawsuit as defendants. Are they still interested in this property? That is true, since they would be your new landlord and inherit the war. You can also tell the prospective buyers all about the defects in the place, the dishonest way in which the landlord has treated you, and that they need to be extra careful when trying to deal with your landlord as the seller. You can ask why their agent didn't tell them about all this. You don't have to keep the place neat, or tie up your dog, or avoid offensive conduct or items. Word will get out, and no real estate agent will show the property. There are too many other properties without problems, and any such purchase would never see escrow close. If an eviction notice is served, you can refuse to let anyone in and change the locks. The rental agreement would have prohibited that, but his notice tore up the lease, so you can do whatever you want. You can sublease and keep that money, because there's no lease to stop it. He gets no rent because he tore up the lease. You fight the eviction for several months or even years with no rent to the landlord, causing the landlord to pay for the eviction. In the end, you win the eviction because it was retaliatory, and then you sue him for malicious prosecution and everything else that applies. Actually, you don't have to wait to win the eviction to start suing the landlord for trespassing, retaliation, fraud, that is, for not telling you about the defects or about his plan to sell the property, unfair business practices, and other bases of a lawsuit. They are not insurable if they're intentional, and therefore the landlord has to pay for his own lawyer to defend himself, not the insurance company's free lawyer, as well as pay out of pocket for what you win. Hopefully, your landlord may calm down and recognize that making $500,000 profit on the house, he can afford to pay you $20,000 and concede to your requests to make that happen. He might have landlord friends who caution him about things that you could do. If he loses $50,000 in sale price just by delaying and agreeing with you, he's lost more than you were asking. You are in control, and you know what you're doing. He has to, as he thinks, lower himself to address you as a human being and work it out. The real estate broker he hired can be your best buddy in all of this, if he's savvy. The broker wants his commission, and the landlord's ego in dealing with you is getting in the way. The landlord has hired the broker for his expertise, and the broker can advise him to accept your offer, or at least bargain in that direction. The broker can tell your landlord horror stories about how tenants can devastate a landlord's sale and life if they know what they're doing. You can call the broker, not the salesman, by the way, and say that he needs to save the sale by convincing your landlord to accept your terms. If he gets arrogant or threatening, you can tell him that he can and will be sued as well, maybe lose his license and be sued for malpractice, all for his mishandling this situation. If he doesn't know What a tenant can do in a situation like this, he needs to get educated fast. Give him a deadline of a week, and then he'll find out the hard way. For all I know, those horror stories could be my client's trailblazing of renters' rights into the real estate sales situation. But you hold all the cards, and the landlord just hasn't been so controlled by a tenant before. In the end, he can't be happy until you are happy, and he has a lot more to lose than you.
If the landlord is evicting you, with or without hostility, it has to be by the book. He cannot break a lease to sell the property, but he can buy out the rest of your lease in an agreement with you. If you have been there less than a year on a monthly tenancy, he can terminate the lease by a 30-day notice. If you've been there more than a year, at least a 60-day notice is required. The important exception is if the sale is already in escrow and the buyer will live there. The landlord can give you a 30-day notice instead. You should ask to see proof that the property is in escrow and make contact with the buyer to confirm it is a person who intends to live there. If he can't meet those criteria or won't tell you that information, you tell him that the full 60-day notice will be required. In most cases, under the Tenant Protection Act, he has to give you the last month free and pay you a month's rent within 15 days of giving you the 60-day notice. If he doesn't do that right, you win the eviction case on that technicality. As I mentioned earlier, even if the right notice is given, if he is evicting you in retaliation for your not letting him trespass, invading your privacy, or interrupting your exclusive possession, it is illegal, and you win on that basis. This situation is why you want to document those early stages of conflict to show the early retaliatory motive, followed by the win-win letter showing that you tried to cooperate and just wanted these reasonable conditions met. He will claim that he just wants you out to sell the property, but you show that if he just accepted your terms, he would not have to evict you at all. It is retaliation for your assertion of rights. Some cities and counties have special protections of tenants who are being evicted because the landlord is selling the property, requiring relocation assistance to be paid to the tenant as a condition of the eviction. These payments may vary upon the age, illness, or having children, but are substantial in the $10,000 to $25,000 range, in addition to refunding the full security deposit. You can find out if you qualify for those payments, which should be in addition to the extra money for which you bargained to cooperate in the landlord's sale of the property.
So there you have it. Knowledge is power. You are in control. You own the right to possession, and you have rights under the lease and the law. You can learn more about all this on the Cal Tenant Law website and in a consultation with one of my lawyers who can guide you through the technicalities. There is no fate but what you make, as one popular movie put it. The law is on your side. Use it.